Rockville. I'm the manager of Long and Foster in Rockville, King Farm.
I'm Joe Hanson. I'm a managing attorney at RGS Title.
Come visit our house as we continue our series on the Maryland real estate contracts. So today we're going to be going over the Montgomery County Jurisdictional Addendum to the GCAAR sales contract. Please be sure you actually have a form in front of you because it'll make it easier to follow. So Joe, help me out as we start with here. The first part is number 1, where the master plan disclosure. Basically in Montgomery County, the buyer has the right to see the master plan. So they just have to sign that they're given the right, not that they've seen it already. Is that correct?
That's correct. It's just the buyer acknowledging that they do have the right and they've been offered the right to review the master plan information for either the county, which is paragraph A, or the city of Rockville, which is B.
Great. If the buyer is purchasing in the city of Rockville, they would be doing number B. It's the same acknowledgement, but for the city of Rockville.
Yep.
So number 2, if the purchaser is buying a property that has private well and or septic, it would have to be checked yes, obviously, and if it doesn't have it, they would check no. If it is yes, then there would have to be a specific GCAAR addendum in the addendum of clauses that would also have to accompany this. Is that
That's
correct?
Right. That's correct, yeah. And as you can see, anytime there's a form referenced, just use the form. So this one references GCAAR addendum of clauses A and the private well and septic. So they've already given you a roadmap, so just go ahead and use that paragraph.
Terrific. On number 3, the transfer recordation taxes. The buyer would have to check whether they're a first-time Maryland home buyer or not. So normally in Maryland, we split the transfer taxes 50-50. So on A, where it says buyer is not a first-time home buyer, and then as you see in the bold, buyer and seller expressly agree that the cost of the state recordation tax, state transfer tax, and local county transfer tax shall be paid as follows. We always put in here split 50-50 just so there's it's clear. Is that correct?
Yeah, I think you want to be as clear as possible when you're completing the contract, and whether or not there's some other type of language in the contract. If there's a line to provide an agreement, I would just suggest providing that agreement. As Janice, as you said, in almost every instance it's going to be 50-50. So I would just go ahead and check the box and put 50-50, and that way you're covered.
So on number B, you're checking that if the buyer's a first-time Maryland home buyer. Joe, you want to explain what that means to the buyer?
Sure. If the buyer is a first-time Maryland home buyer, which means they've never owned property in the state of Maryland as their principal residence, and they are going to use the subject property as their principal residence, they're entitled to an exemption off of one of the transfer and recordation taxes. The state collects a 0.5% total transfer tax, and the buyer is exempt from their 0.25%, so they don't have to pay that. That's a one-time only exemption, so it doesn't reset. If the buyer has been away from Maryland for a while and they come back, they don't get it again. You're just a first time forever. So you have to meet the qualifications as outlined in 3B, and as long as both buyers, by the way, whether or not if there's multiple buyers, all of the buyers have to meet those requirements.
In 3B number 2, in the bold where it says buyer and seller expressly agree that the cost of the state transfer recordation tax and local county transfer tax shall be paid as follows. Mm-hmm. You suggest they again put 50-50.
Yeah, I would just always suggest 50-50, and if 50-50 there still means that the buyer gets their exemption. It doesn't mean that they're all 50-50. They're automatically by law given that 0.25% reduction. So the 50-50 doesn't change that. So again, most of the time it is going to be 50-50.
Okay. Under number 4, the Maryland lead poisoning program. Is there anything you want to say about this?
No, not really. I mean, here is just a disclosure, and as you can see, it gives a hyperlink for more information on the lead poisoning program that Maryland has. So if your client does want to review some more information, I would just send them to that link and send them to that website.
If properties are built before 1978, there's a possibility of lead which has to be disclosed. In addition, there is additional forms that accompany the contract that we will go through at a later time that will accompany the contract also.
Yeah, it's just a disclosure. So you just want to make sure, again, if your property falls into that area, then your seller has to be aware of it, and you got to disclose to the buyer.
Hey Joe, will you
Yes.
talk about the Maryland non-resident seller, which is outlined in number 5?
Sure. So Maryland has a withholding. It's not. They don't call it a tax. It's a withholding fee for non-resident sellers. So as you can see by the paragraph, it says if the property is not the seller's principal residence and the seller is a non-resident individual of the state of Maryland or is a non-resident entity, Maryland would withhold, or potentially would withhold, 7.5% of their net proceeds. So it's sales price minus settlement charges minus any mortgage payoffs, and then it would be 7.5% if it's an individual or trust or an estate seller. I think LLCs or corporations are 8.25%. So it's important to get this information ahead of time, because as you're filling out your seller net sheet, that'll be an issue that comes up. And more importantly, the sellers actually can apply for an exemption with the state if they're otherwise subject to it. So you want to head it off early so the seller's not subject to the withholding at settlement. Any further questions or clarifications, you can go to the comptroller. There's a website there that's cited. You could email over to the comptroller. They could give you more information. But I think the key takeaway here is if they're not a resident, this is a question that needs to be addressed early so that at the very least the seller can avoid the full 7.5% withholding if possible at settlement.
One of the things I like about the Montgomery County Jurisdictional Addendum is the hyperlink. So on number 5, on the last sentence, it says www.marylandtaxes.com. So if the seller or if the buyer wants to get more information, they can click on that and go right to the different websites.
Exactly.
So in number 6, it's protection of homeowners in Foreclosure Act notice. So their seller has certain protections under this if for some reason their house is in foreclosure. Would you like to explain that?
Yeah. So as far as this paragraph, it's just a notice to the parties that if the seller uses the property as their principal residence and they're in default, there are certain protections that the seller actually has. Seller has the right to rescind the contract within 5 days of the latter of contract execution or the date the party signed the statement about tenancy. So again, if your client, if you're on the listing side and your seller is more than 60 days in default, these are types of questions you need to ask when you go for your listing appointment anyway. I think if you're more than 60 days in default, there's probably some other issues as well. But it's just a notice that the seller has certain protections under the state code if you're already under contract.
Thanks. So on number 7, it's just the property tax 60-day appeal. It's just pretty much saying that there can be an appeal of the taxes after the buyer has transferred and owns the property for 60 days.
That's right. They could challenge that property tax if they wish.
So on number 8, the buyer has certain rights. The buyer has the right to select their own title company, which in Maryland is the settlement company. Do you want to say something about that?
Just say again, as you said, Janice, in Maryland, it is the buyer's choice to select the title insurance company. I mean, that's I'm sure some sellers, or particularly if it's an REO or a builder, they'll offer you incentives to go with their title insurance company. But it is at the end of the day the buyer's selection and not the seller's selection.
Also, under number B, the buyer has the right to receive the property disclosure disclaimer statement unless for some reason the seller is exempt, and there is a list of exemptions on that form. The buyer is advised that if there's wetlands that it needs to be disclosed. Also, the buyer is protected if for some reason they feel that their real estate agent or someone has done something wrong to them. There is a guarantee fund, and it can't exceed $50,000. Is there anything you want to say about that?
No, I'll just kind of, just going back to the disclosure disclaimer statement. Again, the buyer has the right to receive that disclosure disclaimer statement. If they get it prior to contract formation, they don't have a right to cancel the contract under a disclosure disclaimer statement. But if they get it afterwards, the buyer does have rights to cancel the contract after reviewing the disclosure disclaimer. So from a listing agent perspective, you want to make sure to the best of your ability that the buyer gets that disclosure disclaimer statement prior to writing the contract, because it's one more out that the buyer would have if they don't have it at time of contract formation.
I believe that's 5 days that they can cancel
right.
it.
Yes.
Perfect.
Yeah.
Under number E, if the buyer is buying in the Chesapeake Bay area, it just needs to be disclosed.
Right.
Under number 9, release of deposit. Do you want to talk about what happens if there's a release, if the contract falls apart?
Sure, that the release of a deposit really can only be released if a title company or another third party is holding it, either by a signed agreement by the parties or by a court order. If Long and Foster or another broker is holding it, the broker does have what's called the 30-day letter right, where if there's a dispute about the deposit, the broker can release it after sending a 30-day letter without response. So basically, the bottom line here is, if there's a dispute about the earnest money deposit, there has to be a signed agreement in order to get it released. Just a suggestion, I would not tell your clients that they're automatically going to get their deposit back should anything happen, because the other party might think that the buyer is in default or something like that. So just be very, very careful about what you're telling your buyers about the release of the deposit, because again, the easiest way to get it back is to have a release signed by the parties.
Perfect. Under number 10, under deposit.
Mm-hmm.
So most contracts in Maryland, the buyer writes a good faith or a earnest money deposit. That deposit, if it's held by the title company, the buyer and seller can agree that the title company can hold it. If it's held by, if it's deposited with the real estate company, all real estate companies are not allowed to hold them. So this is just saying that the buyer directs the escrow agent to hold it. In addition, they're checking whether it's a non-interest or an interest-bearing account. But for practical terms, almost all of our contracts have non-interest bearing, since the return on investment on your accounts is so low. Don't you find that?
Yeah, ours, if we hold it, it's a non-interest bearing account. That's correct.
So at the bottom, the seller and the buyer are both signing them, and this then becomes part of the contract. So thank you for visiting our house today. We look forward to seeing you soon.